Thank you, everyone, for joining us. My name is Britt Burner, and I am one of the attorneys here at Burner Law Group. We have offices, as you may know, out in Suffolk County, 2 on Long Island, as well as in Manhattan. And we practice in the areas of elder law, estate planning, and trust and estate administration. And today we're here to talk about planning, estate planning in an election year. And I think if I could retitle this, I would probably retitle it something along the lines of estate planning in a year where it's almost impossible to plan. We started this year and a lot of things have changed in the past 11 or so months. And there's potentially big changes coming down the line. And I think the one overarching theme that you are going to get from this talk today is to plan. It doesn't necessarily mean that you haven't planned or that you have, but one way or the other, you should be reviewing and possibly changing your estate plan to deal with all of the things that we've seen in 2020. Depending on what your politics and your beliefs are, you may believe that we have a president-elect in President-elect Joe Biden, or you may not believe that. But when one way or the other, you should still be looking at the possible changes that could come down the line. An important thing I like to remind people of when we talk about politics, which we're not getting into the politics of it today, but when we talk about how our system works in this country, just having a president that believes one thing or another doesn't necessarily mean that a change is going to come. And so we're going to talk about some proposals today that maybe have been talked about by the Biden-Harris administration. But again, those are not necessarily going to be things that are going to come into play. There are still some Senate races that are up in the air, and it looks like we may have a Congress that is represented by both parties, maybe not exactly evenly, but pretty close. And so things aren't going to just change overnight, and they're not going to change all in one direction. So that's my caveat here for when we go through this. Also, nothing here today is meant to be legal advice. It's really just meant to be a way for you to start thinking about some things that may be affecting you or your loved ones and possible changes that you may want to be making to your estate plan. But all this is going to require that you speak to your own attorney. If it's our firm or if it's your a separate attorney, you want to make sure that you're speaking to your own attorney about these topics and about how it's going to affect you and your loved ones in your particular situation. So, some of the things that we've looked at in terms of what the Biden-Harris administration has said that they would like to change, we really look at 2 major changes when we're talking about estate planning, when we're talking about planning for after death. One is in terms of capital gains, and the other is in terms of estate taxes. Capital gains tax is, as background, the tax is a type of income tax, and it is owed on assets that are sold that have increased in value. So one example could be if you bought Apple stock for $1 and now it's worth $110, and don't quote me on today's price, I didn't check, but that is $109 worth of gain. And so when that stock is sold, there is a capital gains tax that is paid on that $109 gain. The same thing will happen if you purchase a property. If you purchased your home for $30,000 and now it's worth $800,000 and you sell it, there's going to be a gain that's going to be calculated and a tax that's going to be owed on that. Now that the amount of tax will be affected by certain things, such as if it's your primary residence for 2 of the 5 years prior to sale, you get a $250,000 exemption. So if you bought it for 30 and you are selling it at 800, the gain might be, if you're a single person, the difference between 280 and 800, because it's the 250 plus the 30 you purchased it at. If you're a couple, two people living in the home, you each get that $250,000 exemption. And if you can show there were capital improvements to the property, a new roof, redoing the bathrooms, those costs can also make the gap smaller and the gain smaller, less tax that you have to pay. This is important in this context because one of the things that was discussed was to get rid of what we call a step up in basis at date of death. So if we eliminate that step up in basis, we are potentially making it so that the capital gains tax that is paid by the beneficiaries is going to be a lot higher, or might exist, whereas it didn't before. So if that same individual, let's go with a single individual, bought a property at $30,000, it's worth $800,000 when they die. The current law says that they get what's called a stepped up basis at the date of death. So that means that if it's worth $800,000 when I die, and it's turned around and my beneficiaries sell it for $800,000, then there's no gain and no tax. If they eliminate that step up, then no matter whether it's sold during my lifetime or after my death, if it's sold after my death, my beneficiaries are still going to pay capital gains tax as if they purchased it at that $30,000 or they inherited it at that basis. So they won't get the benefit of having that date of death valuation, which could result in a higher capital gains tax. So that's what capital gains tax currently is. That's what the potential could be for a change. And now let's talk about how is that actually going to affect you? What's really going to be the difference? As of today, as of November 11th, 2020, it probably won't make much of a difference. We don't know what is going to be the actual legislation that goes through, if any, on this topic. And so I wouldn't want people going and making changes based on a potential legislative change that hasn't yet happened. But let's say it does happen. What might you do? Well, there's some people that hold on to these, what we call low basis assets, that Apple that they bought right at the beginning, those assets that they bought at a very low value that have highly appreciated. They might be holding on to those assets because they know as part of their financial plan that at their date of death, they'll get that step up, and then that's how their beneficiaries will inherit. And they're lessening tax for the group, for them and for their beneficiaries. They may not do that anymore. They may sell some of those assets while they're alive and take some of the hit on the tax. Somebody who has a gain in property might have been waiting for that date of death valuation so their beneficiaries could inherit it, but maybe now they'll sell during lifetime and settle for the $250,000 exemption. But when it comes down to it, if that person lived in their home, regardless of what they bought it at and what it's worth now, if they intend to stay there and they can afford to stay there, those people are not likely going to change that ownership status just based on this change, because they're going to want to live in their home. And so again, it's don't make any changes now, but if these things start to change, you're going to want to talk to your financial advisor, you're going to want to talk to your attorney and your accountant about how you might minimize tax for your beneficiaries and for yourself. And depending on what your goals are, you may make changes to your plan. So the other big change that has been talked about would be a higher estate tax. Now, what does that mean and how does that actually happen? Well, currently in the federal government's scheme, if you have less than $11.58 million at your death, and also we add in gifts you gave during your lifetime, then there's no estate tax. So those who have less than $11.58 million, no estate tax on the federal level. That law, as it currently stands, is set to change in 2026. So the current law sunsets in 2026, and for those that die after that date, after January 1st of 2026, they will have a $5 million exemption indexed for inflation. So it'll be probably somewhere around 6 million or just under 6 million. The New York State is currently at 5.85 million. It's going to meet that at whatever it's at in that year. So the current law, again, is if you have less than 11.58 million, there's currently no tax. If at your death, if it's after 2026, you have less than the 5.8 or 5.9 million, there's no tax. Now, it could be that a new administration may lower that exemption level sooner. So it could be that prior to 2026, maybe the 11.58 goes back down to the 5 million index for inflation, or they could legislate for it to go down even further. Again, this is going to be something that's going to have to be negotiated, and there's actually going to be a law that's going to have to be passed, just like the Tax Cut and Jobs Act that created the current law that we have now. So that's a potential for the future. So in terms of what you should be doing year-end 2020, there's not anything to do necessarily in terms of that, but if you are somebody who was already concerned about having assets perhaps in between that 6 million and that 12 million amount, if you're in there, you should be talking to your attorney about future planning for when that law sunsets back to the 5 million index for inflation, and a change in law or a change in this particular part of the law may just make you advance those plans for certain trust planning and otherwise. I want to also point out when we talk about taxes, so I said that for the federal government, it's 11.58 million, but that's a lifetime exclusion amount. So what does that mean? New York's federal government also tells you, as many people know, that you can give away $15,000 a year per person, gift tax free. So what the actual rule is that the first $15,000 each year that you give to an individual is an exempt gift. So if I give you $15,000 each person on this webinar today, there is no gift tax that will ever be paid, and there's no gift tax return that needs to be filed because it's exempt. However, if I give each of you $20,000 this year, then $5,000 of that gift for each of you is a taxable gift, meaning a gift tax return should be filed with my taxes next year, showing that I gave these gifts this year, and that goes against my lifetime exemption, which if I die right now is the 11.58 million, but we know is going to sunset with the current law. And so you have to be careful that when you talk about what assets are being given away in terms of estate taxes, you're looking at life and death gifts when you're looking at the federal government's plan. Now in New York State, we don't have gift taxes. So if I give away $3 million to somebody this year, as long as I outlive that gift for 3 years, so if I live for 3 more years, there's never going to be a gift tax on that money. And it's not includable in my taxable estate because I gave it away. So while I have 5.85 million to give away in terms of my at death in New York State, that 3 million, if I survive it by 3 years, never creates a tax and there's no concern there. So that's important to note. The other big change as we get towards the end of 2020 that I think people need to really take note of are changes that came about in light of the Secure Act. The Secure Act stands for Setting Every Community Up for Retirement Enhancement. It was an act that was signed into law by the president, by President Trump, in December of 2019. And I think it's flown under the radar for a lot of people. Now, again, we're going to talk about what changes were made as a result of the Secure Act. But an important thing to remember is that not all of the laws that are changed will necessarily affect the planning that you will do. So the important thing to note today is to listen to what the changes have been to the law in light of something like the Secure Act, and then to take that information back and see what the impact would have on your own estate plan and your own beneficiaries. And then in turn, see if there's anything that you can do to minimize that tax, or anything that you might want to do to minimize that tax. I have some clients who say, well, the people I leave the money to are very lucky to be receiving that money, and if they have to pay taxes on it, they have to pay taxes on it. Whereas others feel that they want to minimize the amount of tax that's owed by maybe the family unit or them and their beneficiaries, whoever the group is. And so you need to look into whether or not there's any changes for you to make. So before the Secure Act, people who had tax-deferred retirement accounts had to take required minimum distributions when they reached the age of 70 and a half. So if you had that 401k, IRA, 403b, 457 plan, I could go on, these tax-deferred retirement accounts had the required minimum distributions at 70 and a half. There was also the ability for something called an inherited IRA, which allowed for a stretch over someone's lifetime. So what does that mean? If I leave one of these tax-deferred accounts to, say, my daughter can roll it over into an inherited IRA, and prior to the Secure Act, she could take required minimum distributions over her life expectancy. Now, if it's my child, presumably they're 20, 30, maybe more years younger than me. So according to the IRS, they will have a longer life expectancy than I had, and therefore their distributions are going to be much smaller than those that I was taking when I passed away. So she'll roll it over and she'll take a stretch over her lifetime, continuing to allow the rest of the asset to grow tax deferred. That is no longer the case. That is being changed by the Secure Act, and we're going to talk about how in a second. Now, the new Secure Act, the new rules that have come into play, one is that those required minimum distributions, if you weren't taking them already before the Secure Act came into play, you now don't have to take them till you're 72. So no more 70 and a half for required minimum distributions. They're allowing you to defer even longer to take those. You can contribute longer to traditional IRAs. There's changes to what 529 plans for college savings can be used for. They can now be paid, can be used to repay certain student loans up to a certain amount per year. There's a $5,000 penalty-free withdrawal from your tax-deferred retirement accounts, even if you're under 59 years old, if you're giving birth to or adopting a child. And the big change is we've lost the ability to take the stretch over the beneficiary's lifetime on that IRA. There is now a forced 10-year payout for a beneficiary of a retirement account, unless you fall into one of the exceptions. But most people, it will be a 10-year beneficiary payout. So what does that mean? So whereas if I died and my child, maybe according to the IRS chart, had a 60-year life expectancy, they could continue taking small distributions, growing that account tax deferred over the next 60 years, and that was a huge benefit to my child. Now, my child, that same person, will be forced to liquidate that entire account within 10 years. Now, they don't have to take everything in year 1, everything in year 10. They can take it in 10 equal. They can do whatever they choose, but it must be gone at the end of the 10 years. And what else does that mean? That means they also have to pay income tax on that money in that short amount of time, because that is money that I was putting away for my retirement when I was alive, and I didn't pay income tax on that money. That was tax deferred. I was taking distributions maybe before my death and paying income tax on those distributions, but this person, this beneficiary, is going to have to take it over 10 years. And so For those who have very large retirement accounts, this could end up being a big change. The exempt beneficiaries from that 10-year payout rule is your spouse, a minor child, so it has to be the child of the person, a disabled individual, a chronically ill individual, or someone not more than 10 years younger. So I would use, for example, if I were to give my retirement account at my death to a friend or to a sibling who was maybe a few years younger than I was, not more than 10 years younger than I was, they don't have to take a 10-year payout. They can get the stretch over their lifetime. So this is a big change for a lot of people, especially those who have a lot of retirement accounts that are tax deferred. So what can you do? What are the possible changes you might want to make? And again, not everybody is going to make these changes. And since last December when this law passed, I've had a lot of different meetings with different clients, and some have decided to make changes and some have decided to leave things exactly the way they are. The important part was they got the information and they made an active decision as to how they wanted to affect their beneficiaries. So again, you want to plan, you want to meet with your attorney and your advisors, and you want to make sure you're doing what is best and most in line with your goals. You may want to, you will want to review any trusts that you've created that were the beneficiary of your retirement accounts. So if your retirement accounts were going to be payable to a trust for the beneficiary of another, you want to have those reviewed because the terms of how those are going to be dealt with are going to change in some cases based on the Secure Act. So you're going to want to review that. Some may decide to take a lot more than their required minimum distribution while they're still alive and take on some of that tax burden for their beneficiaries. I have heard some advisors and some insurance advisors talk about taking more than your required minimum distribution and using that to pay premiums on life insurance or long-term care insurance or some other product that makes it now no longer a tax deferred benefit to the people that you leave behind when you pass away. You may want to change who are your beneficiaries on which accounts or assets. So if you do have a charity or that sibling that's not less than 10 years younger than you, those may end up being better beneficiaries on a retirement account than maybe your daughter who would be forced to take it over 10 years and is already in a high tax bracket. So you may want to change up the specific bequests in your will or your trust and the beneficiary designations on your accounts. You may want to do other types of planning, especially for those who are charitably inclined regarding charitable trusts. But again, it's not going to be the same for everybody. It's going to depend on what your goals are and who you're looking to benefit and what institutions you're looking to benefit if you do have charities that you are looking to benefit. And the overall, again, 2020 has taught us to plan for what you can't plan for. So you need contingencies in place. You need flexibility in your estate planning. You should have a power of attorney that allows another to act for you should you be unable to act on your own behalf. A healthcare proxy that says you can make medical decisions if you can't make them for yourself, if you are temporarily or permanently incapacitated. You want to make sure that the planning that you have in place is going to take into account the ability to change if there are changes to legislation in the future. Another thing that COVID taught us in 2020 is that the courts can shut down, and they did. And the surrogates courts, which are the courts that deal with probate and after-death administration of estates, they closed down. And since they've opened back up in New York State, they have been backlogged. And it's very hard to get estates through in some counties because the volume is so large. And so a lot of our clients are moving now more towards revocable trusts to avoid probate altogether and to make sure that there's an ease of administration at death, regardless of what happens in the future and what's going on in the county, the state, the United States, or the world at the time that they pass away. Again, we want to be planning for the unexpected. We want to plan for what we can't plan for. And we do that by having documents that build flexibility into everything and allows for someone to be in charge to make changes if you become unable to do so on your own. I am going to answer some questions now. I see a few have come in. I think Liz told you at the beginning, but you can feel free to write them in the Q&A at the bottom. Anyone that I don't get to, please feel free to reach out and email me with any follow-up questions, and I'm happy to help. So I'm going to look at the ones that we currently have and answer those. The 11.85 million, this is correct. It is per person, not for a couple. So for a couple, it's, well over 23 million or over 23 million that you can leave behind. Also, I'll note that for the federal government, there's something called portability. So if the first spouse dies and does not have the 11.85 in their estate, if proper tax returns are filed on that estate, the remaining spouse can file to receive the first to die spouse's unused exemption. So if one spouse dies with $5 million in their name, with the proper filings, the second to die spouse could have their own exemption, which might still be 11.85, depending on when they die, or may go back down to that 5 million number that we were discussing. Plus, they'll have the 6.85 that their spouse didn't use in their estate. New York State does not have what we call portability, that right to share the exemption between spouses. I refer to it more as a use it or lose it. So you want to make sure that if you are worried that as a couple you're over that exemption amount, that there's advanced planning that's done regardless of which spouse passes first. The next question I see is it grandfathered in? I'm not sure what that person's referring to. So if you want to write another question in just to refer, I'm sure you were saying that when I was speaking on a specific topic, what you're referring to in terms of grandfathered in, or you can email me and I'm happy to answer offline. I'll just give a minute unless anybody else has any other questions that they want to ask. One thing I will point out, but we've done some separate webinars on this and we will continue to put out information on this, is today we were talking about estate planning in light of changes mostly on the federal level in terms of administration. But I think an important thing to just point out is that you should also be reviewing your estate planning in light of the fact that New York State this year has changed the Medicaid, community Medicaid rules for eligibility. And we are in a legal gray area right now where the law has been changed, but implementation has been delayed because of the COVID emergency. But there is a look back period now for community Medicaid. So those that believe that applying for Medicaid for home care might be part of their future or part of their plan, now is a good time to speak with an attorney about what planning you might have to do in advance, since there is now this look back period. And so that's just one more thing to throw into the big pool of what happened in 2020 that were big changes that would make you review your plan and again, plan for what we can't plan for. I think that the changes that we're seeing are showing, we all know that we are an aging population. And so it is very important that we continue to plan for ourselves, realizing that government benefits may not continue to be exactly what they always were in the past. And I think what we're seeing with the Medicaid program in New York State is a result of that. We always tell people you should review your estate planning documents about every 5 years or when there's a big change. And that could be a personal change, a death, a birth, a retirement, selling one of your large assets like a home or a vacation home, and that's a good time to review your estate planning. But it's also when there's a big change in the outside world, a big change in the laws. And I think between the Secure Act that changes in the Medicaid law and a potential change in the estate taxes and capital gains taxes, it's a good time to check in and see what should be done in your estate, if anything. I see now this person clarified. So if the Secure Act was signed in December, so if you were already 70 and a half and taking your required minimum distributions, you now can't wait till 72. So you're grandfathered in, I guess, to the extent that you have to continue taking your required minimum distributions. However, if you died, or if your loved one died in 2019, then you are still allowed to get that stretch for the Inherited IRA. But if your loved one died in 2020 or later, the effective date of the Secure Act, then you are no longer able to get that stretch on the Inherited IRA, and you have to take the 10-year payout. So there's some rules that are going to benefit those who died in the past, and then in some ways the individual can delay longer while they're alive, and so it'll benefit others. Then the current look-back period, people are asking. So the new law says that there's a 2.5-year look-back period for home care Medicaid. So there's still a 5-year look-back for the nursing home. And that is not, they're not assessing that look-back period yet. They will not do so before April 1st. It's unclear when exactly they will start, but it is still something to watch. And I know there's some other questions coming in on that, but we'll certainly do another webinar. And there are some, I believe, on our website already that we've done to talk about those changes in the law. And as we find out more information, we're going to continue to put that out. All right, well, I think that is the bulk of the questions for today. Again, if you would like to email me, feel free. My email is bburner@burnerlaw.com. You can always email also at info@burnerlaw.com, which is how you signed up for this webinar. And I'm sure you got an email from us, and I'd be happy to answer any questions or let you know if it's a question that really, some of these questions are better put to a financial advisor or to a tax advisor. So I hope that you all have a wonderful day, and happy Veterans Day. And thank you to all of you who've served. And we look forward to seeing you again in the future. Thanks.